see if you don't.
Oh,
have.
you may be seated.
Thank you.
Okay. Fix the mic. Connect the heat.
Oh, yeah. I'm sorry. Thank you.
Jefferson County Court Law number 2 is back in session. The court is in session in clause number M331406. Case is style of state of Texas versus Stephen Anthony Sampson. Let's see, I think you got it different on here. I think it's Stephen Anthony Sampson Jr. Make sure.
Want me to move the camera, Judge?
No, we want to be on that on the podium. He has it over there. It's over there. And then the other one is on the witness.
So it's good?
Yeah,
Okay.
okay. Case is style state of Texas versus Stephen Anthony Sampson Jr. Let the record reflect that Mr. Sampson is present in court with his attorney, Attorney Dustin Gilmore. Let the record also reflect that the state is present with Assistant Criminal District Attorneys, Attorney Cornelius Williams and Attorney Farrah Nixon. Let the record also reflect that the jury is now present and seated in the courtroom. We have Mr. Tabor, who is on the witness stand, and Mr. Williams. You may begin.
Thank you, Your Honor. Welcome back.
Hey,
We're going to pick up from where we left off. As I recall and a review, it seems we had left off right at the end of the one lady stand test. We'll pick it up from there, okay?
yes, sir. You're good. You're good. All right, second.
Now, this was the conclusion of the third part of the standardized field sobriety test. Is that correct? I'm sorry, Mr. Tabor?
That is correct.
Based upon that, you then effectuated an arrest. Is that correct?
That's correct.
We're going to be placed in arrest for driving while intoxicated, okay? Yes, sir. Really? Yes, sir. Um. Really? Hey, you have a purpose on record to tow your vehicle, sir? No. But, I don't think they're really just free. Like, little things, like, he's waiting on me. Hello? Sir? Yeah, can, like, if I have money, like, could give me? I'm not sure. We were to the county jail tonight, yes, sir? Did we? Yes, sir.
Mr. Tabor, during your interactions with Mr. Sampson, did you notice the manner of his speech throughout that interaction with him?
Yes, sir.
And what was his manner of speech
It was very slurred and slow and sluggish.
as captured on the video on State's Exhibit G, correct?
Correct.
From the point of where you made the arrest, how far? This was in Groves, correct?
That's correct.
In Jefferson County, Texas?
Correct.
Now, from where he said where he lived, we heard earlier in the testimony that he was in a bar in at home first, then he was in Port Neches?
Correct.
Port Neches is close to Grove, we would agree, correct?
Correct.
Now, where you effectuated the arrest in the Groves, how far is it roughly from his home in Port Arthur? Was it right across the street on the other side of the fountain?
I believe it was on this side of town, but I'd have to look at the map. I believe based on where we were, which is the furthest most point of Port Arthur on the east side. He lived way on the west side, somewhere off 15th, I believe it was, or something, which would have probably been several miles away.
So he wasn't right around the corner from his house
No,
when he pulled into that storage place?
correct.
Okay. I'm right there, there's somebody they come give me. Right down the street from your house? Yeah, but you live on the west side, though. No, I don't. Actually, my girlfriend's house is like right down the street. And she works for us. Who is she? She's like, for the government code, I think. For the county? Yeah. Okay. I never took a put me in here, no? No. Okay. That's it, like. Yeah, I'm ready to say, like, she'll come get me. You are. I got a court, like. Dude. Yeah, I'm supposed to know the word, so, like, oh. Come on back in the same something, okay, no.
Now, Officer Tabor, throughout the arrest,
Yeah, there's somebody like.
throughout the arrest, you placed him within the door. Mr. Sampson was cooperative, correct?
Correct.
And you placed him in the rear of your squad or the unit.
Correct. We're right.
And it has an operational camcorder inside there, correct? The camera that captures the backseat?
That's correct.
They couldn't get me? No, so from the county jail, they can. Hey, put your feet in for me, okay? I gotta read you something here in just a second. You got it? Yeah. Go. Found it?
What were you about to read him?
We call it DIC 24 City WI statutory warning.
And did you do that?
I did.
I show you what's been marked as identification, as D1. Do you recognize D1?
I did.
And D1 is the statutory, one.
That's correct.
And how did you convey that to Mr. Sampson?
When we read them this, we always put one in their, like their lap. And then I have one, and we get them to read along with us if they can. And so it's read verbally to them, along as well as them read it along as they can.
And you did that back on in November, early November of 2021.
That's correct.
What accompanies the statutory warning?
There's three DIC paperwork. The first one's a DIC 23, peace officer sworn statement. The second one's a DIC 24, statutory warning. And then the DIC 25 is a temporary driving permit, for refusals.
And did Mr. Sampson refuse back in the late night, early morning?
Yes, it did.
And that is contained in State's Exhibit D.
That's correct.
With that, Your Honor, the state will introduce into evidence D1 and D2. No objection.
Okay, no objections. State's exhibits D1 and D2 are admitted.
Now, from here, we just play a portion of, you did convey that to him, correct?
That's correct.
And it was accurately captured when it happened on your video.
Yes, it was.
Okay.
Sure.
Yes, sir. I did is, actually, that I thought that I was there and so in this part too. Yes. Right. Anyway, right. I'm going to be good. There's a whole lot of trouble. There you go.
What were you doing just in going through your file? I mean,
Pulling out a copy of the statutory warning.
Gary. Because anybody who's right. I'm gonna be good. There's a whole lot of trouble. There you go.
I gotta read you something real quick, okay?
Yeah,
Can you see this?
yeah.
No, I'm ready to see it. You're under arrest, you can follow along if you want. You are under arrest for an offense right now, acts alleged to have been committed while you're operating a motor vehicle in a public place or a watercraft. While intoxicated or an offense under section 106.041, alcoholic beverage code. You'll be asked to get a specimen of your breath and or blood. The specimen will be analyzed to determine the alcohol concentration of the presence of controlled substance, drug, dangerous sugar, or other substance in your body. If you refuse to give the specimen, that refusal may be admissible in subsequent prosecution. Your license, permit, privilege, operating a vehicle will be suspended or denied for no less than 180 days, whether or not you're subsequently prosecuted for this offense. If you refuse to submit to the taking of a specimen, the officer may apply for a warrant, authorizing the specimen to be taken from you.
Yeah.
If you are 21 years of age or older, submit to taking a specimen, and analysis of the specimen shows that you have an alcohol concentration of 0.08 or more, your license, permit, or privilege to operate a motor vehicle will be suspended or denied for not less than 9 days, whether or not you're subsequently prosecuted for this offense. If you are younger than 21 years of age, have any detectable mental alcohol in your system, your license, permit, or privilege to operate a motor vehicle will be suspended or denied for not less than 60 days. However, if you submit to taking a specimen and analysis of the specimen shows that you have an alcohol concentration of less than 0.08, you may be subject to criminal penalties less severe than those provided for in chapter 49 penal code.
Yeah,
You may,
I've heard, yeah.
if you submit to taking a blood.
After he read the forms and after a refusal, did the defendant attempt, breath samples?
Well, we're at the back up there. The first, when I first asked him for, read the DIC, it wasn't a refusal. I asked for a specimen of his breath, which he, said he would give once we got to the Jefferson County Jail.
And did he do that?
I did.
And you were certified as an operator of the intoxilizer back then in November of 2021.
That's correct.
Like to show you what's been marked as state exhibits. E1 and E2. You recognize E1 and E2?
Yes, sir, I do.
And for the members of the jury, what are they?
This is a forensic breath alcohol analytical report. When somebody tries, well, when you get a breath specimen, you usually get two specimens. One, they blow in, it's a 3-minute delay, and they give you a second specimen that reports what the blood alcohol content is.
Now, prior to administering the test, well, let me ask this, where did you administer the test?
It's at the Jefferson County Jail.
And prior to administering the test, was the defendant continuously in your presence for at least 15 minutes?
He was.
Because he's sitting in the back of the unit, correct?
Correct. No, wait, talking about, did I start my waiting period then?
Did you start it while he was in the car, or did you start it once y'all got down to the jail?
No, once we get into booking is when the 15-minute waiting period begins.
Thank you for that. Great clarification. Now, for what purposes during that 15-minute period of time, were you observing the defendant during that 15-minute period of time?
Yes, sir.
And did any of the things you were looking for occur during that observation period?
No, they did not.
Did you check to see if the defendant had anything in his mouth?
Yes, I did.
Please tell the jury how the intoxilizer test is performed.
So going back to the 15-minute waiting period, we do a 15-minute waiting period to make sure, like, suspect regurgitates, burps, throws up. You have to start that 15-minute waiting period over because they'll leave residual alcohol in their breath. So you have to wait for that to dissipate out. Once 15-minute period is up and none of that has occurred, you begin the intoxilizer, start the intoxilizer instrument. And you begin putting your information in, the suspect's information in. It goes through some calibrations, and there's some solution in there. You gotta verify the solution's at the right temperature and all that good stuff. And once all that's done, it'll tell you, hey, it's time to blow.
Was the machine working properly back then on November 7th to November 8th of 2021?
Yes, the instrument was.
And were you able to get a sample of his blood?
I was not.
And could you tell members of the jury, why weren't you able to obtain a sample?
All right, so on there the first time around, it's like a hose that comes up out of the machine, and then we have mouthpieces that you put on there. You change those out every time somebody blows in it, right? And you just put your mouth around it, and you're supposed to blow until we tell you to stop. And that's what captures that breath sample. But you got to blow for, it's not like a minute, but it's not like forever, but it's long enough to where it captures a breath sample. However, Mr. Sampson would either start blowing, you hear the beeping on the intoxilizer instrument start going up, but then he'd just stop. Or there's periods where he'd blow, but I hold the hose going into it, and you can actually feel the breath being blown down onto my hand, kind of like he was trying to circumvent blowing into the instrument.
Now, E1, which is a breath, test of breath sample,
That's correct.
correct? And the time on that was about 12:31,
Yes, that's correct.
21. And what was the result of that first attempt?
So the first attempt is what we call a deficient sample. You have to give a sample within 3 minutes, otherwise the instrument times out and it shuts down.
First one is deficient. Did you attempt to administer the breath test again to
I-
Mr. Sam?
I did.
And that was about at 12:44 or so.
I was about 7 minutes later, so about
Okay.
12:38, 39.
And that is contained on what is E2, correct?
That's correct.
And were you able, excuse me, was Mr. Sampson able to complete the test where you were able to get a registered amount?
No, it wasn't. Same thing occurred.
It was a deficient sample?
That's correct.
Two deficient samples. Based upon that, what, if anything, did you do?
Based upon that, asking for because of DIC paperwork, you can get breath or blood, or you can get both if you want. I asked for a specimen of his blood at that point,
Yes, sir.
and he didn't really give me an answer, yes or no. So ultimately, I took that as a refusal.
And based upon that refusal, what, if anything, did you do?
I applied for a blood search warrant.
And were you able to obtain a blood search warrant?
I was.
And based upon the blood search warrant, what happened next?
Once I got the blood search warrant, Mr. Sampson was brought to the infirmary, where I met with a nurse in there and brought a blood kit.
May I approach the witness, Judge?
Yes, you may.
I show you what has been previously marked and admitted as State's Exhibit N. Do you recognize State's Exhibit N?
I did.
And the nurse who drew the blood, her name is Corinne Yango.
That's correct.
Did you observe Nurse Yango draw the defendant blood?
I did.
Was it in a sterile environment?
Yes, it was.
Did you observe the nurse when she swabbed the arm of the defendant?
I did.
After observing that, it was she cleaned her arm, correct?
Correct.
In a sterile environment, correct? And she drew the defendant's blood, correct?
Correct.
And what does the blood kit, which has been admitted, what does it consist of?
Consists of two blood tubes in it.
Could you open State's Exhibit B, please? Okay. Now, you observed Nurse Yango draw the blood, and then she placed the blood in two tubes.
That's correct.
Could you please take a look at States B1 and B2?
Yes, sir.
Now open it.
One,
One,
we'll do B1.
okay, you open B1.
Yes, sir.
Now, is that the blood that you saw in the sterile room that Nurse Yango drew and put into the tube?
Yes, it is.
How do you know that?
There's a label that comes with this in order to go over the top. That other one, I don't know if that one's been used or not, but this label right here goes all the way across the top here.
Yes, sir.
And that secures that right there. And then everything on here has the suspect's name, my name, the date, the blood draw time, which on here was again 2:53 or 2:33, so it's several hours later. It has Miss Yango's name on it and signature as the one being drawing the blood.
And your name is on that as well.
That's correct.
Once you completed putting the blood inside the tube, did she return the tube to you after y'all initiated it?
Yes, you did.
And what did you do with it?
Always, because sometimes the nurses don't do it enough. You have to invert these things. They have what they call anticoagulant. in the bottom of it and keeps the blood from clotting. So I always take it, I invert it 10 times. It's usually enough to dilute the anticoagulant in there.
Now, you didn't shake it vigorously.
No,
did you?
no, it's just inverted back and forth, upside down about 10 times. That's a normal thing I always do.
And once you completed doing that, what did you do?
It goes back inside here. These are turned, and then it's all put back into here, just like that.
Yes, sir.
This is closed, and this thing comes with a evidence label, red evidence label with it inside the box,
Yes, sir.
which is then I seal it right here. It's an integrity label, and it has my name and the date and all that on it.
You did that.
That's correct.
And after you completed, you sealed it, what did you do?
Once it's sealed and I'm done at the jail, I go to the Gross Police Department and it's placed into evidence locker. Or secured into evidence locker.
Then after that, it's transported to the lab,
Yeah, somebody, detective or somebody.
and then the lab analyze the blood, correct?
That's correct.
It's resealed with the yellow tape
That's correct.
and returned to the Groves Police Department.
Yes, sir, at some point.
In the course and scope of your investigation and of this case, did you learn of the defendant's blood content level?
I did.
And what is it?
Well, it was a 0.229.
And that's greater than a 0.08.
Yes, it is.
It's greater than a 0.05.
Yes.
I'm sorry.
I was about to say, that's like
I'm
below.
sorry, 0.15.
Yes,
Last is bad.
it's almost 3 times the legal limit.
Okay. And then you brought the case to the district attorney's office after you completed your investigation, correct?
Somebody did.
Okay, well, somebody did.
But yes, it was brought to the attorney's office to be filed.
You generated paperwork
Yes.
that corresponds with all the work and stuff that you did on the case. You made the file up,
Correct.
and then somebody brought it to me.
That's correct.
And did that conclude your involvement, with the case until testifying now?
That's correct.
Well, just once again, do you see the person whom you encountered back in the early November, 7th and 8th in 2021 here in court today?
Yes, I do.
And can you please just point them out, identifying, knowing what it was clothing?
Sitting at the defense table wearing a striped shirt.
If it hadn't been made a record, reflect the quote identification.
We previously
Yeah.
stipulated to that.
Okay,
Um,
okay. Let the record reflect that the witness has identified the defendant.
One moment, John, please.
Okay, Mr. Galmo?
Yes, sir.
Hello, hey, where are you?
Good, how are you?
Good, we know each other.
Yeah.
We've had cases before, haven't we?
Yeah.
All right. So I'm gonna ask you just a few questions about that night.
Right.
Probably won't go over a lot of it again, so be a little quicker. Number one, when you first saw Mr. Sampson's vehicle, it was not moving, correct?
The vehicle not moving?
The vehicle was not moving,
That's correct.
and it was not on, the roadway, right?
Not on the main travel part of the roadway.
And then I think if I remember from the video without pulling it up, there was a shoulder to the road, right?
Not right there is not really a shoal. Oh, there's a little bit, but he was pulled off into the driveway, which was still part of the right of way where the feeder road was.
And we could pull it up again if we need to, but you don't remember that there's
But,
a white solid line?
Yeah, but I mean, how wide a shoulder are you? Yeah, I mean, yeah, there was a little bit of side to that feeder road.
Okay, and then once you'd say get a car's width off the white solid line, then you would be technically in the drive. Would you agree with that?
Correct.
And then I think you said he was like 30 feet off of the driving area. Is that what you said?
Yeah, the roadway, the main trail,
Yeah, 30 feet. So he was in the driveway, right?
Yeah.
Wasn't anywhere in the road or blocking cars or anything like that?
no, sir.
Okay, I just want to make sure. Something else that you said in your testimony that I want to go back over because it just seemed, was it said that when you saw the vehicle, I think what you said was the brake lights are on, so either that meant his foot was on the brake, or at least you said you thought maybe his foot was on the brake. Do you remember what you said?
I don't remember what I said. I would say that his foot was on the brake because the brake lights were illuminated.
You've seen this video though, right?
Yes, sir.
Did you ever notice when you got out of the car, what the lights did?
I did not.
You didn't notice? Can we play that real quick? Hold just that, just the portion where he's gonna get out of the car. I mean, the TVs are pretty bright. I don't know if we need to turn off lights. We're just gonna play about 10 seconds. While he's pulling that up, Officer Tabor,
Right.
let me ask you a question. So do you consider yourself, on one side or the other when you're testifying in this case? Or do you consider yourself a witness who's just here to say what happened?
I'm witness to what I did.
Okay. Whenever, you put things in your report, you put things in there that you think are important, right?
That's correct.
Because you might need to remember them later.
That's correct.
You might not remember everything that happened 5 years ago, right?
That's correct.
Okay.
What is it, you think you are?
I think so.
You think you're good to drive?
Yeah.
Okay, well, I wanna make sure you are still good to drive, okay? Someone do a few tests, if you're good to
1
drive.
minute before that?
I'll feel good. Right? Then I'm good?
Yeah.
All right. Hey, what do you do? Take time.
What the, oh, good, this is not full. No, Judge, I unplugged, I hadn't plugged it back in, Judge.
Yeah, but still turn it off.
No, this is,
Do you remember if you put, that Mr. Sampson has his foot on the brake in your report?
Yes, it is.
Okay, is that in the probable cause report or is that in your full report?
I don't have the probable cause report, affidavit, so it's in my, report,
Okay,
my written
what paragraph is that in?
second. First sentence.
Okay, so yeah, you said that the brake lights were illuminated.
Yeah.
But to be fair, I think yesterday or 2 days ago, you testified that his foot was on the brake. It's not exactly the same thing though, right?
Well, I was,
It's your assumption.
that the bright lights were illuminated, that his foot was on the brake.
Okay, but to be clear, you did not make a determination his foot was in fact on the brake.
Yeah, like, when I looked inside the vehicle, yeah, I'm not gonna be able to, I don't recall that.
Okay. If his foot was on the brake, that would mean he is physically manipulating the vehicle in that moment, right?
I mean, his foot's on the brake.
He'd be physically manipulating the vehicle in some way, right? If he was doing that. I'm asking. Yes?
Yeah, I mean,
Yes.
yeah,
Okay, so it's important. That's important, right? Would you agree? That's important. If his foot was on the brake or not in that moment.
if he's awake and his foot is on the brake, then I would say so, but if he's not aware, or if they're sleeping, somebody's sleeping, they're passed out, and their foot's just on the brake too, they may not at that point either, so I don't.
1 minute, Harvey. No, it's gonna be 1 minute after. It's not here. I think it has to, no, it's just way right after that. Two minutes later. He's gotta wait for another officer to arrive. While this is playing though, the lights look illuminated?
Mhm.
Okay. Just take a mental note of how they look right now. Mr. Williams, if you want to skip 30 seconds, you can. Go ahead and hit that 30-second skip button. Okay, 30 seconds later, does it appear the lights are the same?
Is he out yet?
Yes?
Yeah, I would assume so.
Okay.
Yeah.
Let's go 30 seconds later.
Yeah.
30 seconds later. Lights are still the same. He's still in the car right now, right?
It looks like it.
Guys, lights are still the same.
Yeah.
The other car's not here yet, so I don't think he's about to get out. Go ahead and skip another 30 seconds, save some time. The other vehicle hasn't arrived. Okay, lights are still the same 30 seconds later. Would you agree?
Yes, sir.
Okay. Skip forward again. Okay, the other car's arrived. So let's just give it a second. Let's watch it. I think he's about to get out, right? As soon as the other officer arrives, I think he gets
Yeah,
out.
I'll probably have to concede that because I don't see a third brake light illuminated either. And it might be the LED lights in that tail light that makes it bright looking.
Now you're looking in the car right now, right?
Talking to him.
Okay. But you
I
testified.
mean, and
You did not verify if his.
I didn't, yeah, I mean, I don't recall.
Okay,
So
that's fine. And while we're waiting, I believe when, about the time he gets out, you tell him to turn the vehicle off, right?
Yes, sir.
And he did.
After being asked a few times.
Okay. But he did turn the vehicle
Yes,
off
sir.
and then he got out of the vehicle.
Yes, sir.
Okay.
What we done?
Nope, he hadn't got out of the vehicle yet.
There he is.
Okay, so now he's getting out, right? And so I believe once he's fully out of the car, the vehicle is now turned off, right?
That's correct.
And just to be clear, the lights have never changed.
Yeah.
Right.
You're right.
So it was a fairly safe assumption to believe that the brake lights looked to be on, right?
Yeah,
And that would normally only be the case if someone's pushing on the brake, right?
that's correct.
Or maybe an emergency brake.
That's correct. No, Mercy, bro?
I don't know, you know, I don't know.
I don't think so.
I don't
I
know.
don't know.
I'm gonna have to test that later today. But like you said a minute ago, it could be just those style of lights make it look like the brakes are illuminated, right?
Yes, sir, I think so. The way those are LEDs, but once you look at it, yes, the third brake light on there is not illuminated. All vehicles that are manufactured now with third brake lights.
Okay, so it just wants to be completely, you can stop that side.
What is it?
Just to be completely clear that we're all on the same page. There is actually no evidence that Mr. Sampson was pushing on the brake anytime that you arrived during that transaction. Isn't that true?
That's correct.
Okay, so we'll make sure. Okay, so, whenever you approach the vehicle and you first looked in the car, I'm gonna try to describe him so we don't have to pull up the video. We can if we need to. What he looked like.
Mhm.
He was seatbelted in.
That's correct.
He was slumped over like this.
That's correct.
He actually looked like he had his phone was about right there.
I don't know. I think I can look, yeah.
Okay. You don't have any reason to believe that's not the case though, right?
That he
Had
Had
his
his-
phone in his lap?
No.
Okay. At least when you first looked in, you didn't see him messing with the radio?
No,
You didn't see him changing with the gears?
No,
You didn't see him rolling up and down windows?
no,
He wasn't doing anything, was he?
no,
He was completely motionless.
correct.
And then, of course, you wake him up, right?
That's correct.
Now, some people, when they're intoxicated, they're real belligerent. He really wasn't belligerent. wasn't he?
It was not.
Some people get real combative, but he wasn't combative, was he?
That's correct.
Some people are cooperative, and he was basically cooperative, wasn't he?
Correct.
He never resisted though in any way, really, right?
No, sir.
Now, he had just woken up. So let's just put intoxication aside. When a person just wakes up, they're not always thinking clearly, right? When a person just wakes up, they're not always thinking clearly immediately.
Possibly.
Intoxication probably not help that either, would it?
No,
You're intoxicated and you just woke up, you're probably really out of it. Wouldn't you agree with that?
correct,
Might take a little while to get your senses together.
correct.
You said, well, let me back up. One of the things I noticed in the video when you were doing the one-legged stand,
Mhm.
I think you testified to the jury that you would have them count 1,000, 2, 1,000, 3, 1,000.
Yes, sir.
You know, that just
1,001, 1,002, 1,003.
supposed to be that way, right?
But it's gone back and forth through different SFST refresher updates,
I think the
so
book says
So-
though, basically 1,001, 1,002
1,002.
is natural counting language.
So,
And 1,002, 1,000 is not natural, and then
No.
eventually you get to 10 and it starts messing you up or something like that, right?
well, I don't know, again, that was, the manuals change and the studies change, so I don't know what it is now, that's no different than the way equal tracking and pupil size was, used to go as fast as you wanted, but now it's recommended you just do 2 seconds, 2 seconds.
Right.
So,
Needless to say, based on field sobriety test, you believe Mr. Sampson was intoxicated.
that's correct,
Now, you get to the jail and you want him to take blood, or you want him to take breath, and he says yes, right?
that's correct,
And then he blew, and then he wasn't blowing hard enough or long enough or whatever, so eventually you decided after 2 deficient samples were returned from the machine, that that's a refusal in your mind.
No.
Well, no, I apologize, yes. It wasn't until you asked him for the blood.
Yeah, and then he wouldn't answer yes or no, then
Right.
they deemed it as a refusal.
And really, correct me if I'm wrong, but that's just a little bit of a matter of efficiency, because assuming if he's not answering your question, will you give the blood? What's gonna happen is you get the nurse come in there with the needle and you say, hey, we're gonna go ahead and take your blood. And he says, well, I'm not gonna do that. Well, now you've got to go get the warrant. And now there's been another delay. So whenever someone's just not giving you an answer, you just go ahead and get the warrant, right?
That's correct, because if they're not getting you yes or no, then
To be fair, if the nurse came in there with a needle, he might have agreed to give the blood. We don't really know, but and what happened was he just didn't answer and you put that as a refusal.
that's correct.
And it doesn't really change the end game as so far as getting the blood results, but you read the DIC 24, and correct me if I'm wrong, because you put that down as a refusal, his license suspension doubled. I believe you read to him in that DIC 24 that if you refuse, your license will be suspended for 180 days. If you fail, it'll be like suspended for 90 days.
I don't know what you mean by doubled. Oh, because he refused?
Yeah, 90 and 180s.
I don't know what happened, because that's a separate issue at hand. That's what we call ALR, Administrative License Revocation Hearings, which is a civil side of driver driving versus the criminal side. So I don't know what happens there at that point.
But
It could have been,
But you told him if he failed, it'd be 90-day suspension, and if he refused, it'd be 180. That's what you told him.
yeah, based on DIC, yes.
Okay, all right, just want to make sure.
Yeah.
You mentioned you inverted the blood. That's something you're told to do, right?
Yeah, that's something I've
All
done from day one.
important steps, right?
That's correct.
Would it surprise you that Memling at the Jefferson County Crime Lab believes if you don't do that, it's okay?
Objection, that's mischaracterization of the testimony, Judge.
She said she's never had an issue with anyone not inverting the blood. I'll rephrase the question.
Okay.
Would it surprise you that if you didn't invert the blood, that Mem Lane has never had an issue with that in the past.
Objection vague, Judge.
Answer the question or.
What's the question?
The question is vague and it's also called for speculation.
Okay, sustain.
Do you think it's best practice to invert the blood, make sure the anticoagulant mixes properly?
That's what I do. I don't know what every other person does. I do that because that's what I was taught to do, to make sure that the anticoagulant mixes with the blood, to make sure it don't clot.
That's what you're taught to do, right?
That's what I'm taught.
Just to go back, I really want to make sure, I think the most important part of this case is when you arrived on scene and what you found, and so, you never saw him driving at any time that night,
No, sir.
before, after, I mean, not even earlier that night.
No, sir.
If the car was already stopped before you arrived,
That's correct.
and you never saw him manipulating the vehicle in any form or fashion.
No, other than sitting in the driver's seat and with the seat belted in and ignition on.
The vehicle was completely into the driveway, completely off the road.
Correct.
It was not blocking anybody or anything.
Just the driveway.
It appeared he intentionally parked the car because it was in park.
Yes.
I'll pass it.
Okay. Mr. Williams?
Officer Tabor, I'm sorry, Aaron, Mr. Tabor. How did the turtle get on the fence?
Somebody put it there.
How did that car get over there in the groves? At 12:30, excuse me, 11:30 at night, back on November 7th of 2021.
Somebody drove there.
When you pulled up on the scene after seeing the lights of the car in which contained Mr. Sampson, you didn't see him drive. But was the car being operated?
Yes, it had.
And when you walked up, when you saw him passed out behind the wheel of the car with his head hanging down, was the car being operated? Because the engine was running.
Yes, sir.
That's with the judge.
Do you know when he was driving earlier that night?
I do not.
Do you know when that car parked in that spot that night?
I do not.
Did you look for any security videos that were on any commercial buildings in that area?
No.
I mean, storage facility surely had cameras, right?
Well, you'd be surprised. I mean, that's what we had. We never had cameras.
Did you
So,
ask?
so
them?
no, we had no surveillance video was retrieved from any of the businesses.
So you didn't look for businesses that had cameras, right?
No.
But you also didn't ask the storage facility if they had cameras.
No.
Did you even look to see if you could see one up there?
I'm pretty familiar with where they're at, and they're nowhere close to that area that would have captured anything.
And you base that on discussions with people who own the cameras.
That's based on when I was in investigation, I used to investigate deaths that occurred there. I know where the location of those cameras are on the corner of the buildings, which is nowhere where we're tagged in front of that gate.
So to be clear, you did not in any way look for a security video that might have captured when he pulled his car in.
No, I did not.
Had this been a murder case, do you think you would have done that?
Objection, Judge. Not only does it call for speculation, the answer calls for, no, I'm gonna say that, objection, call for speculation. We're talking about this particular case.
It's not speculation if he would have worked at it. If you know-
Objection relevance,
So you know-
what's the relevance to?
Okay.
A murder case?
Objection sustained, no relevance.
So is a DWI crime not important to you?
It is.
Okay, well, did you do everything you could to try to pinpoint when he drove up, or what condition he would have been when he drove up?
Not at that time of the night, I did not.
And did you do it another day?
No, I did not. Someone said, when it said investigations.
And so you did not try to investigate his condition when he drove up or when he parked his car?
No, I did not.
That's what.
You knew his conditions based upon, sorry, you knew his conditions based upon your interaction with him, with his slurred speech, correct? With
That's
his, when you told him to turn the car off with him fumbling inside, correct?
That's correct.
And when you had him outside the car, and when you asked him about, is that vomit and urine? And he said, well, it's not urine.
That's correct.
Based upon all that and the safety of this community is the reason why you arrested him that night, because that car was operational and he had been behind the wheel of the car.
That's
Right.
correct.
I
Thank you.
don't guess.
Okay, Mr. Tabor, this will conclude your testimony. You're free to go, and you have a blessed day.
Thank you.
We asked that he make the excuse, Judge.
It's fine, Judge.
Okay, all right.
You
You're released.
All right, thank you.
One moment, John, please. You say proceed, Judge.
Yes.
With that, the state rests this case in chief.
Mr. Gilmore?
State's gonna rest. We need a brief recess.
Okay. At this time, ladies and gentlemen, you can follow the bailiff out into the hall. It'll be a recess. You may be seated. Mr. Pickens. Move that camera a little more where we can.
Build up.
It's gonna be to, right, yeah, we are right there. That's good. Okay. Okay. Ms. Galmore, you may proceed. Well, before we do that, let the record reflect that we're back in session and call number M 331-406. Case is filed in the state of Texas versus Stephen Anthony Sampson Jr. Let the record reflect that Mr. Sampson is present in court with his attorney, Attorney Dustin Galmore, state is present with Assistant Criminal District Attorneys, Attorney Cornelius Williams, and Attorney Farrah Nixon. And let the record also reflect the jury is now present and seated in the courtroom. State, are you ready?
State is ready, Your Honor.
Defense, are you ready?
Ready.
Okay, Ms. Galmore, you may proceed.
Judge, this time the defense rests.
Okay, now, ladies and gentlemen of the jury, the defense has rested their case. The state has rested their case also. There's no rebuttal. And so, ladies and gentlemen of the jury, the court has prepared a charge, and I'm going to read to you the court's charge. Members of the jury, the defendant, Stephen Anthony Sampson Jr., stands charged by information with the offense of being intoxicated while driving or operating a motor vehicle in a public place. The offense is alleged to have occurred on or about the 7th day of November 2021 in Jefferson County, Texas. The defendant has entered a plea of not guilty. Our law provides that a person commits an offense if the person is intoxicated while driving or operating a motor vehicle in a public place. A person is deemed to be intoxicated within the meaning of the law when such person does not have the normal use of physical or mental faculties by reason of the introduction of alcohol, a controlled substance, a drug, a dangerous drug, or a combination of at least two of these substances or any other substance into the body, or to have an alcohol concentration of 0.08 or more. A public place means any place to which the public or a substantial group of the public has access and includes, but is not limited to, streets, highways, and the common areas of schools, hospitals, apartment houses, office buildings, transport facilities, and shops. Now, if you find from the evidence beyond a reasonable doubt that on or about the 7th day of November 2021 in Jefferson County, Texas, the defendant, Stephen Anthony Sampson Jr., was intoxicated and while so intoxicated, did drive or operate a motor vehicle in a public place in Jefferson County, Texas, then you will find the defendant guilty. Unless you so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for or otherwise charged with the offense give rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution prove excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in his presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The bailiff will then the question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted in evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. Our law provides that a defendant may testify on their own behalf if he elects to do so. This, however, is a privilege accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed you cannot and must not refer or allude to that fact throughout your deliberations or take into consideration for any purpose whatsoever as a circumstance against the defendant. You are the exclusive judges of the facts proven, the believability of the witnesses, and the way to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a full person, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. Now, the last page is the verdict form. There are two sections, one at the top and one at the bottom. The top section states, We, the jury, find the defendant not guilty as charged in the information with driving while intoxicated. If that is your verdict, then your foreperson will sign on the top line. And it says, or we, the jury, find the defendant guilty as charged in the information with driving while intoxicated. If that is your verdict, then your foreperson will sign on the bottom line. Does everyone understand? Okay. At this time, we will begin the closing arguments. State, you have the opportunity to go first. You have a right to open and close the summation.
State respectfully request 20 minutes total time. We ask for 5 minutes be reserved in rebuttal, Your Honor.
Okay, so you have 15 minutes in fact. Okay. Okay, State, you may proceed.
Thank you.
And I'm keeping the time. Okay.
Ladies and gentlemen of the jury, Your Honor, the judges gave to you the charge which identified a list of elements the state must have proven for you to find the defendant guilty of driving while intoxicated beyond a reasonable doubt. I believe that the evidence presented by Mr. Williams these last few days proved that the defendant, Mr. Sampson, on or about November 7th, 2021, in Jefferson County, Texas, did drive or operate a motor vehicle in a public place while intoxicated. I want to remind you of the testimony you have seen to prove these necessary elements. However, we're going to tackle them in reverse order. First, was the defendant intoxicated? According to Texas Penal Code 49.01, intoxicated is defined as not having the normal use of mental facilities by reason of the introduction of alcohol into the body, or not having the normal use of physical faculties by reason of the introduction of alcohol into the body, or having an alcohol concentration of 0.08 or higher. We have seen and heard testimony proving that Mr. Sampson did not have the normal use of his mental faculties beyond the introduction of alcohol because of the introduction of alcohol into the body. In the body camera and dash camera videos, we heard the defendant state that he had one Boilermaker at home in Fort Arthur. Then he admitted that he had a few more, before finally admitting that he had been to a bar in Grove. By the defendant's own admission that night, he did not know where he was. When questioned, he told Officer Tabor that he thought he was in Port Neches that night, when he was actually in Grove. And I Googled these locations because I've only been in Beaumont for 3 weeks. I don't know the geography very well. So what I found out is, well, he also said that he lived right down the street, but as Officer Tabor testified, the defendant did live across town from where he was found. And he wasn't one street over, and it's not like he just took one turn. We have also seen and heard testimony proving that Mr. Sampson did not have normal use of his physical faculties because of the introduction of alcohol into his body. As you saw in the body camera footage, the defendant moved his head multiple times while Officer Tabor performed the horizontal gaze astigmat test, that eye test where they watch the eyes. Despite Officer Tabor repeatedly instructing him to hold his head still. And according to Officer Tabor, the defendant failed this test, finding a lack of smooth pursuit and distinct and sustained nystagmus at maximum deviation in both eyes. You saw the defendant attempt the nine-step walk and turn test, where he was instructed to walk 9 steps, count the steps out loud, fully turn around, and take 9 steps back. And what did the defendant do? He walked a number of steps uncounted, and then instead of turning and walking back, he walked backwards, back to where he was. Officer Tabor said this was a divided attention test, which he testified consisted of an instruction phase and an execution phase. The point being that a person cannot know what they need to do, let's say drive a car. And the second phase of this test is to check if they can remember what they need to do and actually perform the instruction, as in driving a vehicle in a safe and lawful manner. We also saw the defendant fail the last standardized field sobriety test, the one-leg stand test. Here, the defendant was instructed to stand on one foot and extend his other foot with his arms at his side. Then he was instructed to count the time as he stood with 1, 1,000, 2, 1,000, and so on, until Officer Tabor told him to stop. In this test, the defendant eventually picked his foot up and put it down a few moments later, not under the direction of Officer Tabor and without following the counting instructions. Okay. Additionally, we have seen and heard testimony proving that Mr. Sampson had an alcohol concentration of 0.08 or higher. Memlina Ultima Marino, a forensic scientist with the Jefferson County Regional Crime Laboratory, testified and demonstrated that the blood alcohol content of the defendant on the night in question was 0.229. We can all agree that the fact that the 0.229 is higher than the number than the Texas state limit of 0.08 is just math. All the testimony we have discussed this far indicates that Mr. Sampson was indeed intoxicated the night of November 7th, 2021. The second element that we'll discuss is that the state needed to prove was the defendant in a public place. A public place is defined, as was in the charge, as a place to which the public or a substantial group of the public has access. It's located in Texas Penal Code section 1.0740. The videos showed, and Officer Tabor testified, that the defense vehicle was an entranceway of a business, the store facility at 6701 Gulfway in Grove, Texas. As defined by the Texas State Penal Code, and as Officer Tabor testified, the defendant's vehicle was in a public place because any member of the public that rents a unit from this facility or visits this facility has access to the entrance where Mr. Sampson parked his vehicle. And discussing the third necessary element, the Texas Penal Code also defines what constitutes a motor vehicle in section 32.34. A motor vehicle is defined as a device in, on, or by which a person or property is or may be transported or drawn on a highway, except a device used exclusively on stationary rails or tracks. By this definition, the red Chrysler Mr. Sampson was driving, which is a device in which a person is or may be transported on a highway, is a motor vehicle. The last element of the DWI that I want to revisit the testimony on and the evidence of was the defendant operating motor vehicle. There's no legal definition of what operating a motor vehicle means. And this is where your knowledge and ability to reason will come in. The key was in the ignition. The engine was running. The headlights were on. And the defendant was slumped unconscious in the driver's seat. As anyone who has ever driven a car can tell you, operating a vehicle involves actions. Can we agree on that? That it involves action. Here, action was taken to sit in the driver's seat. Action was taken to put the key in the car's ignition. And action was taken to turn the key and start the engine. If two more actions were taken by the person in control of the vehicle, the person in the driver's seat, using their ability to observe, their ability to respond, and their ability to follow the instructions of the law, if they took two more actions to place the car to drive or reverse and put their foot on the gas pedal, then they would take their current abilities and faculties down the road or wherever their current abilities and faculties would take them. The defendant stated in Officer Tabor's body cam footage before they started the field sobriety test that he was good to drive. During that video as well, he said that he had to go to work. And at this point, I'd like to remind the jury that to determine if someone was operating a vehicle, you can look at the complete picture of what the evidence and circumstances of the situation shows you. And you can infer or draw conclusions based on that evidence and testimony that you have been shown. Ladies and gentlemen of the jury, you may infer from the facts presented and conclude that since operating a vehicle involves actions and actions were taken that are needed to drive a car, Here, the fact that the vehicle was not moving does not negate the fact that the defendant was operating the vehicle. So did the defendant, Mr. Sampson, on or about November 7th, 2021 in Jefferson County, Texas, the store was located on 6700 Walkerville Way, which is located in Grove, Texas, which is in Jefferson County. Did he drive or operate? The key was the ignition was running, and he was sitting in the driver's seat. A motor vehicle, red Chevrolet, in a public place, an entranceway to a business the public can access, while intoxicated in every manner defined by law. Not the least fact that he had BAC of 0.229 with a legal threshold of 0.08. Since the state was able to prove that every element required by law was present in this case, the jury must find the defendant, Stephen Sampson Jr., guilty of the crime of driving while intoxicated. Thank you, ladies and gentlemen of the jury. Thank you, Your Honor.
Okay. Okay, that was 9 minutes and 36 seconds. Okay. Mr. Gilmore, you may proceed.
Sure, thank you, ladies and gentlemen. We're finally done. It really kind of turned out the way I expected it to. This is slightly unusual trial because there really wasn't a lot of dispute as to what the facts were in the case. The facts are really kind of what they are. I told you in opening what I expected in the case the facts to be, and I believe that they pretty much turned out exactly like I suspected. On November 17, 2021, Mr. Sampson was drinking. He drove a vehicle, and while he was on his route home, he pulled his vehicle over into a private drive. He parked his car, he put the car in park, and he went to sleep. Now, he had his phone in his lap. See that in the video. It wasn't turned on. When the officer pulled in, he said that Mr. Sampson was asleep, not doing anything at all. Now, he did field sobriety tests. They showed signs of intoxication. He was arrested. He gave blood with a warrant. He gave blood and showed his above legal limit. So that's basically what I told you. You can see an opening, and that's basically what happened. So really, what's the question is? The question is does he meet the elements of the offense? So let me look at this charge a little bit. This is the charge the judge just read you. He's going to give you a copy. You can look at it in the back. There's really only a couple of things I wanted to point out that I thought were really important that we may not have talked a lot about beforehand. Number one, he's presumed to be innocent, right? Anyone charged with a crime, you're presumed to be innocent. So we're not presuming that he's intoxicated and is there some evidence that maybe he didn't drive while intoxicated. We're presuming that he did not drive intoxicated. The question is there evidence that shows that he did in fact operate a motor vehicle while he was intoxicated? The government has to prove that. They have to prove everything. We don't have to prove anything at all. The element that I told you in the beginning is going to be important is the while element, right? There may be evidence of intoxication in the case. The question is, does the evidence prove that he was intoxicated while he was operating the motor vehicle? The judge told you that when a person doesn't testify, that's not evidence. You're not supposed to use that for any purpose. And then he also told you you have to reach a unanimous decision. Actually had a jury one time send a question to the court and they said, what is the definition of unanimous? So unanimous means everybody has to be on the same page, right? Everybody has to say guilty or not guilty, or you just don't reach a verdict. And right, if you notice in here, nowhere in here does it say you have to reach a verdict, okay? Because really the way a jury trial works is you have 6 people.
Objection, Judge, that's improper. He's arguing for jury nullification.
I'm just pointing out that the
Objection overruled.
So like I said, the jury charge does not tell you you have to reach a verdict. The way it works is we have a 6-person jury or a felony, we have a 12-person jury. Each person evaluates the facts, comes to their own conclusion. And if everyone's conclusion is the same, well, then that's how the trial works and everyone can return that verdict. No one can make you change what you believe. Okay, so this trial is about what you believe and you come to your own determination. No one can make you change your mind. In fact, if someone makes you change your mind, I would say that that means the system really didn't work in that particular situation. Now, some of the points that I made with the officer, won't go over all of them again, because they're probably not all relevant here, but the main thing is that, where the officer found Mr. Sampson, the conditions that he found him in, and let's see. That's really it. I mean, there are other things that we discussed about the test aren't really relevant in this particular case. And so one of the comments though that the state made, was two more actions. And I kind of agree with the state there. What she said was two more actions and he could have been driving down the road, right? And I agree with that. Two more actions, he would have been operating a motor vehicle, right? He required those two additional actions though. Or at least one. I mean, if he had the car and drive and he's manipulating the vehicle, I believe that's what operating means. In this charge, if you notice, the very end, it says, we, the jury, find the defendant guilty or not guilty of the information with driving while intoxicated. Okay, now the definition that you're gonna find is operating. They don't use the word driving. If the law was that a running car is operating, then that's what the law would tell you in here. That's what the offense would be called. But the operating is not defined. Operating is what it means to you. I would suggest that it means some sort of physical manipulation, right? Would it be different if he was in the passenger seat and the car was running? Would it be different if he's in the back seat and the car was running? So is it the car running or is it the physical manipulation of the vehicle? There's a note I wrote down here. Let's see. They have to prove he's operating a motor vehicle, not sitting in it, not sleeping in it. No officer saw him drive. The officer never saw the car in motion. The officer never saw Mr. Sampson touching the vehicle other than sitting in it or doing anything with any instrumentation in the vehicle. The vehicle never moved. He was not in the road. He was off the road in a private drive. The officer never said that he was really concerned with what might happen in the future because we don't charge people with what might happen in the future. As far as we know, Mr. Sampson could have woken up and driven. He could have woken up and called for a ride. He could have woken up with a car that had run out of gas and he could have walked. So really what we're deciding here is that the government proved that he was intoxicated while he was operating the motor vehicle. And I would suggest to you that the evidence just simply does not show that. Being inside of a running car is not default operating a motor vehicle. I would ask that you consider that. There's no evidence of when he drove last or his condition. Maybe we could have had it if it was more important to the officer. I suggest to you that if it was a robbery or a murder, we would have it, right? We would have the security videos, but because we don't have them, we don't know. That is a reasonable doubt. And I'd ask you to return the verdict on that.
We don't have it because we didn't need it. The officers did not need it that night, back in November of 2021. There was no need for that. Why was no need for that? Because on that night, over there in the groves, the police officer was acting in his public protection capacity. He was looking out for the safety of the individuals. Now, the jury instruction is clear. Would there be a distinction just by applying a plain reading of the law? If driving was the same thing as operating, you will see while driving or operating a vehicle. If it was the same, it would read, if the person is intoxicated while driving or driving, the car does not have to be moved. Ladies and gentlemen of the jury, when we first began this journey together back in Guadalajara, all that we required of the state is that you listen to the evidence within the case which is being presented. You hold the state to our burden beyond a reasonable doubt. We welcome that burden. And I submit to you, I place before you that we made that burden. Now, that car was in fact running. It wasn't way off the road. And council kept pointing out, as you just heard, it's in a private driveway. Well, once again, we know what is defined by being in a public place. Private driveway, but a public place. It is immaterial as to when exactly that he got there. And this is the reason why, because that car was operational. All he had to do, wake up, put the car in any gear, and the car would have moved. It is not required by the law within the state of Texas that you have to show him driving. He had access to the car. He was operating the vehicle while he was intoxicated, not one way, not two ways, but all three ways. We've shown that beyond a reasonable doubt. Why is the charge that way? Is that driving while is driving while driving or operating? It's because he had access to that vehicle while he was in fact intoxicated. Now, let's not get confused about the facts. Had he been asleep, let's just ignore the facts for counsel argument to make plausible sense that will not offend our traditional notions of what is common sense. If he's in a back seat in the car turned off, no lights on, nothing illuminated. Let's see how you're doing. Keep in mind, okay, no key in the ignition. He's in a back seat of the car, lights turned off, not where it's located. I don't think that we would be here today. What is the difference? We cannot ignore the particular facts of this particular case. Passed out and behind the wheel with the car running and the lights on. I submit to you that that is operating and all elements have been met. You've seen the video, you guys listened to the testimony within this case. You saw how he got out the car. You also saw how his clothes was disheveled, belt was over, and is that vomit or urine? Well, it's not urine. He didn't say he didn't vomit. So he pulled the car over. He was clearly intoxicated. You have all the facts before you. Based upon each of you all's common experience, that's how you factor the evidence. You look at it, did the state meet its burden beyond a reasonable doubt? And when you go back there, you do not check your common sense out here at the door. You guys all agreed that you will follow again from the law, apply the law to the fact. That's all that we ask. And by doing so, we believe that you should find Mr. Sampson, the defendant here, guilty beyond a reasonable doubt.
Okay. Okay, ladies and gentlemen of the jury, at this time, the evidence, the court's charge and the closing arguments of counsel are before you. I'm going to hand the charge to the bailiff, and he will escort you into the jury room. Everyone, please step down. Follow the bailiff. We stand in recess until the jury has reached the verdict. You may be seated. Okay, full person. Have you reached a verdict in this case?
Yes, we have your honor.
Is this verdict unanimous? That is one that is agreed upon by all the jurors?
Yes, sir.
Please hand the verdict form to the, but please hand the, yeah, the whole charge and verdict to the bailiff. Okay. Mr. Sampson, would you please stand now? Let me do this here. Madam Full Person, is the verdict the unanimous verdict of all members of the jury?
Yes.
Okay. And Mr. Sampson? Say, we the jury find the defendant not guilty as charged in the information with driving while intoxicated. Okay? Anyone like the jury poll?
No.
So, yeah.
Okay, you may be seated. We have letters.
Yes, this should be over there.
I think I have six.
You have six?
No, I have the one.
Okay, but yes, should, okay.
Oh, never mind.
Oh, you have another?
Yeah, I guess.
Oh, you have enough? Okay. Okay. Trina, we have enough. Okay. Ladies and gentlemen of the jury, first of all, I'd like to thank you for taking out your time to serve as a juror in this case. I know that like most people, we have other things to do, but it's because of people like you in our community that we're able to move our docket. I mentioned to the members of the panel on Monday that I know they say that those who were not selected, they were disappointed. But a lot of times, as I mentioned to them, they think that they wasted their time, but they did not waste their time because, as I mentioned to them, our cases in the morning, we have a lot of cases going on. And we had a jury docket, and because of people that show up to serve as jurors in the case, we are able to move our docket. If you don't show up, we can't move our docket. And so I'd like to thank you for taking time out from your busy schedules to be here to participate and make sure that justice is done in Jefferson County, particularly in the County Court at Law Number 2. Now, as I mentioned to the other members of the panel, I know that when you came to court on Monday, you looked over the top of the door and you said, "Oh, this is County Court at Law Number 2. This is Judge Holmes' court." No, this is not my court. This court is for the citizens of Jefferson County. I'm only an humble public servant. You are the citizens of Jefferson County, so therefore, this is your court because I like to think that County Court at Law Number 2 is a people's court. And so I've said that to say this. Anytime that you're in this area, you can come and have a seat in that area we call a peanut gallery, but you can't bring peanuts in here and eat because this is not the Texas Roadhouse. But you can come and have a seat in your courtroom to see what goes on in Jefferson County. And I know that you will find it very interesting. And I know that you found this case to be very interesting. And so anytime you're in the neighborhood, you can come have a seat in County Court at Law number 2, or if you're unable to make it, obviously we're on YouTube, and so you can come and see what goes on. You can view YouTube and see what goes on in our county. Now, your jury services is complete. And since your services are complete, you can take your badges off and you can put them on the counter. Yeah, you'll pick them up. Now, I usually, like I tell people, I usually give everyone a handshake. We have COVID in our communities, and we also have the flu and some other things. But however, I like to give each and every one of you an air handshake. And thank you for being here. Now, the attorneys may want to talk to you. You don't have to talk to any one of the attorneys if you don't desire to talk. If you want to talk to them, you can. If you don't, that's fine as well. Now, if you need any excuses, this is after 4:30, so the district clerk's office is closed. No, that's not the excuse. That's just a letter. We can we can give you an excuse for work or something like that. So just remain in the courtroom, and then our court coordinator will call you over so that she can get your name, and then she can give you a letter that you can use. You had your hand up? Oh.
Work or school?
Okay. So at this time, your services are concluded. Again, on behalf of the citizens of Jefferson County, on behalf of the staff here in County Court at Law number 2, thank you for paying attention, and thank you for being very attentive and participating in this trial. So at this time, you're free to go. Everyone, please have a blessed day.
I'll bring it up too.
Yeah, you can, actually, you can sit right back there.
Y'all can send.
She's typing them up right now.
Thank you.
Okay.
Thank you.
Yes, sir. Thank you very much.
God bless you.
Thank you. Appreciate you.
Thank you. If you don't have an excuse. Not to drive it. You want to. Not to drive it. That was this. No.
And this will conclude this trial in County Court at Law number 2. Jefferson County, Texas, Judge Terrence Holmes presiding. Everyone, please have a blessed day.
Timeline for it.